You want to talk to us a little bit about competence and cooperation?
Kind of getting down to, well, what does this all mean? It sounds extremely basic, but it starts with meeting the duty of competence. The ABA, well, the Alabama rules of professional conduct have not been amended in any way to reflect this. The ABA rules and the commentary to those rules have been revised to reflect that encompassed within the duty of competence is staying abreast of technology as it impacts the matters you're handling for your client. And that includes not just being able to handle electronic evidence in litigation, but also, I would argue, knowing how you can use litigation to better serve your clients in general, whether it's investigatively, saving time, saving money, that sort of thing. But you need to know the law. There are rules of civil procedure, both state and federal, that speak to ESI and how to handle it and how it is to be dealt with in discovery. How do we apply the rules of evidence to the handling of electronic information? And how do we handle the electronic information so that you can later prepare to have it admitted in whatever proceeding you're in? You need to know your limits. I'm not advocating that everyone needs to start following all of these Twitter feeds and go to a week-long program or become certified by some of the certifying agencies that are out there. But you need to know the basics as it applies to your practice, and to the extent that you are engaged in a matter that goes beyond your limits, you need to either bring on board a vendor or associate counsel to assist you with that, or, I think what you would call worst-case scenario, handing the case off to someone entirely is certainly not preferable, but it needs to be considered just like any other area of the law that's outside of your expertise or your own competency. A big chunk of what you can do is twofold. One of them is very low tech. Document, document, document. As to your clients, we all have certain bits of advice, certain bits of information, certain issues we address in writing, just so that later there's no question. Scope of representation, most of the areas of your engagement letter, your engagement agreement you want, and in some cases are required to have in writing. Included with this is going to be a litigation hold to your client. Now, am I saying you have to do a written litigation hold in every case with every client? I don't know that you would go that far. Your insurance carrier may have a different view of that, but obviously if you have a client you have worked closely with for an extended period of time, and this is not their first rodeo either, and they have some level of sophistication and competence in these issues as well, you probably don't need to do that every time. But what you need to consider each time is this a client or is this a case where you have a potential for your client to later come back and say, well, I didn't know. I didn't know I needed to take these steps, or I didn't know I needed to save this evidence. I didn't know that when I got a new cell phone, I needed to collect the text messages off of my old one that are relevant to the matter that I came and met with you about and that I hired you for. I didn't know how to do it correctly. The Flurry case that Judge Putnam talked about earlier had something very basic as far as documenting with opposing counsel. In the Flurry case, the defendant had made a written demand to plaintiff's counsel for an opportunity to inspect the vehicle. Plaintiff's counsel never responded to that letter. That is probably going to be an issue if there is malpractice litigation between that client and that lawyer. So before we even get to tackling the technology issues involved in handling ESI, there are some very basic matters about being a good lawyer and being a careful and prudent lawyer in handling some of these things. The second major step you can do is to use a belt and suspenders approach to preservation, whether it's evidence that your client has, or an opposing or potential opposing party has, or a third party may have. Loss of evidence entirely is a one-way trip. Once it's gone, it's gone. We can get into issues later about how to collect it. We can get into issues later about how to transfer it from one source or one site to another in a way that maintains your ability to authenticate it and get it into evidence. We can deal with all that after the fact. We can deal after the fact with the issues of whether you have to produce it or not, whether it's within the scope of discovery. But loss of evidence entirely is a one-way trip that you want to avoid. So go back and rethink the degree to which you are papering your recommendations to your client on preservation and the analysis of whether to send preservation demands to opposing counsel or to any third parties. There's another case that involved sanctions from a couple of years ago for loss of evidence. Some people call it the ESIRT Hot Moms case, where you had a wrongful death case brought by the husband of a woman who was killed, and somewhere around the time of the initial meeting between that widower husband and counsel to proceed on a wrongful death case, the attorney advised his client, by the way, defense lawyers are getting very savvy about collecting evidence from social media. So if you have anything on Facebook or Twitter or anything that's going to be worrisome, you need to clean that up, which the plaintiff did, including eliminating a picture of him wearing a shirt that said, "I heart hot moms." Now, the defendants, being the savvy lawyers that the plaintiff's lawyer advised against, had already collected that picture and pressed this issue substantially through the course of discovery and in deposition, and were able to successfully obtain monetary sanctions. And those sanctions were imposed against both the lawyer and the client. That sounds like the makings of a malpractice claim against the plaintiff's lawyer for the recommendation to, quote, clean up social media. So that goes back to twofold. One, know the law and know that something like that would be spoliation. And two, paper these issues with your client as far as the advice you're giving them on preservation. To the degree you need to bring somebody else in and assist you with a case, whether it is a vendor, whether it is co-counsel, some sort of project manager or contract lawyers, you can delegate, but you need to supervise. Now, there is a little bit of a catch-22 here, because there is the issue of how do you properly supervise somebody that you brought on board because of expertise you don't have. But what you cannot do is entirely turn something over to a non-lawyer, either in your firm or outside your firm, and wash your hands of it and say, okay, I've engaged a vendor, it's handled. The last thing to keep in mind is, to the degree you can remove any of these issues entirely from the litigation through working with the other side, do so. There's a very high likelihood that some of the issues you're facing, the adverse party may be facing as well. In these divorce cases, in these cases where maybe resources are limited on both sides, you may have parties and lawyers on both sides that don't have the sophistication or the resources to have a vendor come in and forensically collect all the information off of a computer or a phone. If both sides are going to be confronted with these same issues, why not agree up front on how to address them? And also, why not remove the cost issues that are going to come up if this explodes into sanctions proceedings or spoliation motions later? If you remove it from an issue in the case, it's not an issue your client can raise later in a malpractice claim, or at least not with great difficulty. So even though we're talking about the role of technology in your practice and in litigation, a lot of what you need to do is very old-fashioned and very low-tech.
I want to add that in the I Heart Moms case was out of West Virginia, and you can Google that. I think it was $750 million sanction from the award that they originally got through wrongful death, and then the attorney at least had his license suspended.
There were disciplinary proceedings against the attorney, and he did surrender his license for a period of time. Now, to a degree, that case is not necessarily a good example to set up a malpractice claim, because there was still a multi-million-dollar recovery, and you can sit here and armchair quarterback after the fact whether it would have been more of a multi-million-dollar recovery. But while the facts are, I think, very illustrative of some issues and concerns in the malpractice arena, the outcome of the case doesn't really necessarily support any sort of a malpractice suit.
Well, the attorney was, and the client both were sanctioned. The attorney was sanctioned somewhere close to 500, and then the client, the plaintiff himself, was sanctioned for the balance of that.
Yeah, and another takeaway from that case is, while you may advise your client to get things off of social media, you darn well better preserve it. You don't just delete it. You don't close the social media account, because on most social media platforms, that results in the loss of all the information that was there. I've had attorneys argue that, well, it's like having your client cut their hair or shave their beard. Well, no, it's not. I think ethically that if you advise your client to get things off of social media, you still need to preserve it somehow, because it's going to be discoverable. And if you're not able to produce it, you're going to get into a spoliation issue.